I need to tell you something that most couples never talk about until it's too late. One of you will likely spend the last decade of your life alone. That's not pessimism. That's statistics. And if you haven't planned for it, your surviving spouse could face financial devastation during their most vulnerable years. Think about this for a moment. Women typically outlive men by 5 to 7 years. But that's just the average. Many spouses end up alone for 10, 15, even 20 years. During that time, they face mounting healthcare costs, potential nursing home expenses, and the brutal reality of living on a single income after decades of planning for two. Here's what makes this even more critical. The decisions you make today about your estate will determine whether your spouse lives comfortably or struggles to pay bills. Whether they keep the family home or lose it. Whether they maintain their dignity and independence or become a financial burden on your children. Most people think estate planning is just about writing a will and naming beneficiaries. They couldn't be more wrong. Real estate planning for a surviving spouse requires understanding tax implications, healthcare directives, trust structures, and income streams that can last for decades. It's about creating a financial fortress that protects your loved one when you're no longer there to help. Let me share a story that illustrates why this matters so much. I knew a couple, married for 42 years, who thought they had everything figured out. They had a will. They had life insurance. They owned their home outright. Then the husband passed away suddenly at 73. His wife was 70. She thought she was prepared. Within 18 months, she was struggling. The life insurance money seemed substantial at first, but she didn't understand how to invest it properly. She kept it in a savings account earning almost nothing. Meanwhile, her property taxes went up. Her healthcare costs skyrocketed. She needed home repairs she couldn't afford. The money that should have lasted 15 years was gone in 7. She spent her final years living with her daughter, having lost her independence and her home. This tragedy was completely preventable. With proper estate planning, she could have maintained her lifestyle, her home, and her independence. So let's talk about what you need to do right now to protect your spouse's future. First, you need to understand the survivor's income gap. When one spouse dies, household income typically drops by 30 to 50%, but expenses only decrease by about 20%. Social Security benefits get reduced. Pension payments often stop or decrease significantly. If the deceased spouse was still working, that entire income stream disappears. This creates a massive financial shortfall that catches most surviving spouses completely off guard. To address this gap, you need multiple income streams that continue after death. Life insurance is the obvious starting point, but it's not enough by itself. You need to think about annuities that provide guaranteed lifetime income. Consider setting up irrevocable trusts that generate ongoing cash flow. Look into dividend-paying investments that create passive income. The goal is to replace the lost income with reliable, sustainable sources that don't require active management. Second, healthcare planning becomes absolutely critical. Medicare doesn't cover everything, and the gaps can be financially devastating. Long-term care is the biggest wild card. The average nursing home costs $75,000 to $90,000 per year. Assisted living runs $40,000 to $60,000 annually. Even in-home care can cost $30,000 to $50,000 per year. Without proper planning, these expenses can drain an estate in just a few years. You have several options here. Long-term care insurance is one solution, though it's expensive and getting harder to obtain. Hybrid life insurance policies with long-term care riders offer another approach. Some people choose to self-insure by setting aside dedicated funds in a health savings account or special trust. The key is making this decision now, while both spouses are healthy and have options, rather than waiting until it's too late. Third, you must address the tax implications of inheritance. Many couples unknowingly set up their estates in ways that create massive tax burdens for the surviving spouse. When assets transfer incorrectly, the survivor might face capital gains taxes, estate taxes, or income taxes that could have been completely avoided with proper structuring. Consider this example. If you own investment property jointly, when one spouse dies, the surviving spouse only gets a step up in basis on half the property. That means if you bought a rental property for $200,000 and it's now worth $600,000, the survivor could face capital gains taxes on $200,000 of appreciation if they sell. But if the property was held in certain types of trusts, the entire property could get a step up in basis, eliminating that tax burden entirely. Fourth, you need to think about control and protection. A simple will leaves everything to your spouse, which sounds loving and straightforward. But it also leaves them vulnerable. Vulnerable to financial predators. Vulnerable to their own poor decisions during grief. Vulnerable to remarriage situations that could disinherit your children. Vulnerable to lawsuits or creditors. Revocable living trusts offer much better protection. They allow your spouse to benefit from assets while protecting those assets from various threats. You can structure trusts to provide income while preserving principal. You can include provisions that protect against cognitive decline. You can ensure assets eventually pass to your children even if your spouse remarries. You maintain control from beyond the grave, but in a way that protects rather than restricts. Fifth, consider the emotional and practical aspects of financial management. If your spouse has never handled investments, paid bills, or managed complex financial decisions, suddenly dumping everything on them after your death is cruel. They're grieving, possibly dealing with their own health issues, and now they have to learn financial management under pressure. Start transitioning financial responsibilities now. Make sure both spouses understand where accounts are held, how to access them, and what the overall financial picture looks like. Create a financial roadmap document that explains everything in simple terms. Introduce your spouse to your financial advisors, attorneys, and accountants while you are still alive. This preparation makes an enormous difference in their ability to cope financially after you are gone. Sixth, don't forget about digital assets and modern complications. We live in an increasingly digital world. Online banking, cryptocurrency, digital photos, social media accounts, and cloud-stored documents all need to be addressed. If your spouse doesn't have access credentials, they might be locked out of critical accounts and information. Create a secure digital legacy plan that includes passwords, account information, and instructions for accessing everything. Seventh, plan for cognitive decline. This is the elephant in the room that nobody wants to discuss. If your spouse lives another 10 to 20 years, there's a significant chance they'll experience some degree of cognitive impairment. Dementia, Alzheimer's, or simply the normal aging process can affect financial decision-making ability. Your estate plan needs to account for this possibility. Durable powers of attorney are essential. But go further. Consider setting up automatic bill payments. Establish relationships with trustees who can step in if needed. Create clear guidelines for when financial control should shift to adult children or professional managers. Include provisions in trusts that trigger when cognitive decline is diagnosed. These safeguards protect your spouse from financial exploitation and poor decisions during vulnerable periods. Eighth, think about the family home. For many couples, the house represents their largest asset and their emotional anchor. But maintaining a home alone can be physically demanding and financially draining. Property taxes, insurance, maintenance, repairs, and utilities don't decrease just because one person lives there instead of two. You have several strategic options. You could plan for the home to be sold after your death, with proceeds going into income-generating investments. You could set up a trust that covers all home expenses, ensuring your spouse can stay as long as they want. You could create a plan that allows your spouse to downsize when they're ready, with clear instructions on how to handle the transition. The worst approach is no approach, leaving your grieving spouse to figure it out alone. Ninth, coordinate all your beneficiary designations. This is where many estate plans fall apart. You might have a beautiful trust structure and a well-crafted will, but if your retirement accounts, life insurance policies, and investment accounts have outdated or conflicting beneficiary designations, your entire plan can be undermined. Review and update all beneficiaries regularly. Make sure they align with your overall estate planning strategy. 10th, consider the impact of remarriage. This is uncomfortable to discuss, but it's reality. If your spouse is relatively young when you die, they might remarry. Without proper planning, a new spouse could end up with assets you intended for your children. Prenuptial agreements can help, but they're awkward to suggest to a grieving widow or widower. Better to build protections into your estate plan now through properly structured trusts that provide for your spouse during their lifetime but ensure assets pass to your children eventually. 11th, don't forget about personal property and sentimental items. Financial assets are important, but family heirlooms, photo albums, jewelry, and personal collections also matter. Create clear instructions about who should receive what. Consider writing personal letters to accompany specific items, explaining their significance. This prevents family conflicts and ensures your spouse isn't burdened with difficult decisions about distributing personal property. 12th, plan for the unexpected. What if both spouses die simultaneously in an accident? What if your spouse dies first, contrary to statistical expectations? What if you both become incapacitated at the same time? Your estate plan needs contingency provisions for all these scenarios. Name backup executors, trustees, and beneficiaries. Create clear succession plans that work regardless of the order of death. Now let's talk about common mistakes that can destroy even well-intentioned plans. The biggest mistake is procrastination. People know they need estate planning, but they put it off because it's uncomfortable to think about death. Every year you delay is a year of unnecessary risk. If something happens before you create a proper plan, your spouse faces the exact nightmare scenario you are trying to prevent. Another major mistake is using DIY estate planning tools without professional guidance. Online legal forms and software have their place, but complex estate planning requires expertise. Tax laws change. State laws vary. Your unique financial situation might require specialized strategies. Saving a few $100s on attorney fees can cost your spouse hundreds of thousands in taxes, legal battles, and financial mismanagement. Failing to update your plan is equally dangerous. Life changes. Laws change. Financial situations evolve. An estate plan created 20 years ago might be completely inadequate today. Review your plan every 3 to 5 years at minimum. Update it after major life events like births, deaths, divorces, significant financial changes, or moves to different states. Not communicating your plan is another critical error. Your spouse needs to know what provisions you've made. Your adult children should understand the general structure. Your executors and trustees need to know they've been appointed and what their responsibilities will be. Secrets and surprises during grief create confusion and conflict. Here's what you need to do right now, today, to start protecting your spouse's future. First, schedule a meeting with an estate planning attorney who specializes in elder law and long-term care planning. Not a general practice attorney. You need someone who deals with these specific issues daily. Second, gather all your financial documents. Account statements, property deeds, insurance policies, retirement account information, business ownership papers, and debt records. Create a comprehensive inventory of everything you own or know. This becomes the foundation of your planning. Third, have an honest conversation with your spouse about money, health, and future care. Discuss your wishes. Understand their concerns. Talk about scenarios you hope never happen but need to prepare for anyway. These conversations are difficult but absolutely necessary. Fourth, calculate the survivor's income gap. Figure out exactly how much income your household would lose if one of you died. Then identify how you'll replace that income. This exercise often reveals gaps in planning that need to be addressed immediately. Fifth, review all your beneficiary designations and make sure they're current and coordinated. This simple step can prevent massive problems later. The bottom line is this. One of you will almost certainly face years alone. The question isn't whether that will happen. The question is whether you'll prepare for it or leave your spouse to struggle through it unprepared. Every day you delay this planning is another day of unnecessary risk. Your spouse gave you decades of their life. They built a future with you. They trusted you to be their partner. Don't betray that trust by failing to protect them when they'll need it most. Estate planning isn't morbid or pessimistic. It's the ultimate act of love and responsibility. Start today. Not tomorrow. Not next month. Today. Your future self and your surviving spouse will thank you for it.